Hello everyone, welcome to the NPTEL online certification course. Our course titled Medical Law. So as you know, we were at the 6th module, so which was on medical jurisprudence and forensic science related and other allied fields. So we discussed various lectures. So today we will discuss the last lecture of this 6th module. Overall it is a lecture 30th, which will be on the how to collect the evidences for the forensics related. Myself, Dr. Chaitanya Mittal, as medical legal consultant at Dr. B.C. Roy Multi-Speciality Medical Research Center, IIT Kharagpur. So today we will be taking last lecture of the 6th module, which was on medical jurisprudence and forensic science. So this is a lecture 30th of our course Medical Law. The title: Collection, Preservation and Dispatch of Forensic Evidences. So the various important topics which we will cover in this lecture are the chain of custody, which is very important, how to maintain and preserve the chain of custody while collecting the evidences. Second, the collection of forensic evidence. Third, evidence tampering. Fourth, presentation of medical reports to the courts. So in the last previous lectures we discussed the duties of the doctors, the various legal procedures, admissibility of the forensic evidences. So today we will discuss how to do the collection, preservation, dispatch, maintaining the chain of custody of various forensic evidences. So the important keywords of our lecture is the chain of custody, government scientific experts, including even forensic pathologists, the doctors, fabricating false evidence, destruction of document. So coming to the introduction of our lecture about the collection, preservation and dispatch of forensic evidences, the forensic evidence is of paramount importance in the criminal justice system in India. Forensic science offers an impartial and scientific foundation for determining the culpability or innocence of a suspect, identifying those responsible for criminal activities and ascertaining the factual details of a case. Utilizing forensic evidence in criminal cases enhances the transparency and accountability of the criminal justice system, hence ensuring the administration of justice. So the forensic evidence, what do you mean by it, or how its importance? So it refers to the evidence that is acquired using scientific techniques and subsequently presented in the court of law for the administration of justice, to give a justice to the victim. It encompasses both tangible and electronic evidence collected from the scene of crime, victim, suspect or any witnesses involved in the incident. It also includes the DNA analysis, ballistics, toxicology, digital forensic, fingerprint analysis, and there are many allied health facilities involved in it, like forensic biology, that is a serology part, all the blood or body fluids related, how they are important or give the DNA analysis. Already told about the forensic ballistic, the firearm involvement or the scene of incident, there is a presence of firearm or firearm related deaths. All the poisoning cases comes under toxicology. Digital part, digital forensics, fingerprints available at the scene of crime to identifying the accused or the culprits who are involved in the various crime scenes. So there are many fields, these are the few being mentioned. So the chain of custody, the chain of custody establishes a clear record of individuals involving in collecting, handling, analyzing and transferring the evidence, as well as the location where the evidence was maintained. In order for the evidence to be admissible in the court, it is necessary to establish in the court that the evidence has been handled in accordance with the correct chain of custody. Chain of custody is a legal concept that pertains to the orderly process in which the pieces of evidence must be managed in order to effectively investigate a case. Common sorts of evidence include blood, DNA samples, fingerprints, footprints, documents, photographs, videos and reports. If any evidence submitted in court has had a disrupted chain of custody, it is inadmissible in a court of law. So, whenever there is a damage in a chain of custody or there is any tampering, it is not possible to admit in a court of law. So, definitely it is very much necessary from the investigator point of view to maintain chain of custody about all type of evidences, any body fluids, saliva, blood stains, any urine sample, any vomitus sample, any DNA related samples, anything, what all evidence is being collected, clothes or even the ligature mark or the tape lifted fibers from the ligature mark in a case of asphyxial deaths like hanging, drowning cases, firearm, any swabs, cotton swabs in sexual assault cases. So, a lot of evidences can be collected, but it is very much necessary to maintain the chain of custody. The chain of custody must be consistently upheld by designated individuals who possesses the legal authorization to handle the evidence, such as police officer, forensic experts, evidence technologists and court personnel. So, it is very much necessary to maintain the chain of custody under law enforcement agencies. So, coming to the judgment, very famous case of Mukesh and other versus state of Delhi and city of Delhi. In the case of Mukesh and others versus Delhi in a year of 2017 of the Supreme Court ruled that a DNA sample can be used as evidence in court only if it is demonstrated that there were no mistakes made during the sampling process and that the sample was not tampered with, because any DNA can come up while sampling process. So, it is very much necessary to do the DNA sample analysis while performing the test to match the DNA, because while involvement any human error can occur or the person who are involved. So, it is very much necessary to do the test without any mistakes or without any tampering. So, the collection of forensic evidences, how we have to do it, there are various guidelines. In a case of especially sexual assault victim survivors, it is completely mentioned in a Ministry of Health and Family Welfare guidelines. So, how to do or what is the primary objective of forensic science laboratories in India is to gather the evidence from scene of crime and conduct analysis on the collected sample using various scientific disciplines such as physical, chemical, biological and digital sciences. So, it is very much necessary for the forensic science experts or forensic science laboratory people to gather the evidence from various scene of crime or either even from the doctor side, from the hospital, wherever they got an evidences for the particular incident happened, and they will do the analysis on the basis of the evidence received, either that is a physical, either soil or anything, chemical, any serological, biological, any body fluids, any DNA sample, fingerprint, digital sciences, photography, anything can possible. So, the procedure for collecting forensic evidence are specified in the Code of Criminal Procedure CRPC. So, the examination of accused by medical practitioner under section 53 of the Code of Criminal Procedure 1973 pertains to the forensic assessment of a defendant. This provision enables a medical practitioner to conduct an examination of an accused individual upon the request of police authority. The medical examination enables the collection of forensic evidence such as DNA, blood sample and various body fluids from the accused. So, coming to the section 53A of the CRPC, which says that if a person is detained for a rape or sexual assault or attempted rape, then there is a sufficient reason to believe that a medical examination could yield relevant evidence, and law permits a licensed medical practitioner to do such an examination. So, the famous the news clip about the section 53A CRPC, samples collected from accused must be sent to laboratory as soon as possible, said by the Supreme Court. There should not be any delay. This is very much recent news clip of the live law in the May 2023, that the Supreme Court recently, while setting aside a death sentence imposed on a convict for allegedly sexually assaulting and killing a minor girl, observed that the samples when collected shall be sent to the laboratory without any delay, so that possibility of contamination and the concomitant prospect of diminishment in value can be ruled out if further noted. So, there shall be a compliance. So, it is very much necessary there should be undue delay in sending the evidences collected either from the victim or survivor and even from the accused. So, it should be sent immediately. So, coming to the next section of the CRPs, that is a section 165. Under this section, the police possesses the authority to conduct searches on the individual or commercial establishments. If there are compelling justification to suspect an individual of engaging in criminal activity, the search may be conducted either with or without a warrant authorized by the magistrate. The search can be utilized to collect forensic evidence encompassing documents, electronic devices and other items that may be pertinent to the investigation. So, the various reports of the certain government scientific experts from various forensic science laboratories, according to the section 293 of the Criminal Procedure Code 1973, any document that seems to be a report from a government scientific expert can be used as evidence in any inquiry, trial or other legal procedure which has a document evidence. So, government scientific experts include chemical examiners, experts of fingerprint bureau, ballistic experts and others. So, where their reports can be used as documentary evidence, but still if there is any doubt, they can be also called for testimony to prove the accuracy of that particular report and evidence. So, this is a famous news clip on the section 293 CRPC from in a year of 2022. The ballistic report forwarded by lab director or deputy or assistant director under the seal is admissible in evidence, said by the Supreme Court. Supreme Court observed that a ballistic report forwarded by a director or even deputy director or assistant director of a lab under the seal can be said to be in compliance with the statutory requirement under section 293 of the CRPC, says that it follows any document purpose to be a report under the hand of a government scientific expert to whom this report is being considered. So, this report sent by the ballistic expert under the seal, definitely there should not be any tampering, is admissible as an evidence, as a documentary evidence in a court of law for the administration of justice. If there is any doubt, he or she can be called for even testimony, but definitely they can be considered or admissible as documentary evidence. So, coming to the next about the section 27(1) about Prevention of Terrorism Act. If a police officer investigating a case wants to obtain samples of handwriting, fingerprints, footprints, photographs, blood, saliva, semen, hair or voice from a person who is reasonably suspected to be involved in an offence under this act, they can request the court of a chief judicial magistrate or the court of a chief metropolitan magistrate to allow them to do so. Definitely, to prevent the Terrorism Act, the police has a power to take the samples from a suspected person, definitely after a request or approval from the court. So, coming to the next. So, these all collection of forensic evidences, there are a lot of things it can be collected by the doctors, forensic science experts or police. So, there are many people or technology experts to go at the scene of crime and collect the forensic evidences, but it is very much important how the collection is important. Similarly, the preservation of forensic evidence is also very important. If it is not being preserved properly, the report does not come accurate and there can be a doubtful or the dubious, which can be taken a benefit towards the defense lawyer side, and the accused can not be proved as guilty and get an acquittal. So, the preservation of forensic evidence is also important. From who all are the experts involved in collection, the preservation also important. So, coming to the preservation, the evidence preservation is the systematic safeguarding of the information that could be pertinent to a possible or ongoing legal action, ensuring its integrity and preventing any alteration, loss or destruction. Evidences found at crime scene degrade over time if they do not promptly gathered and preserved for analysis. Definitely, if they are not properly preserved, there can be a formation of various fungi, algae, any tampering can be done, or even degradation also with the time. So, it is very much necessary to preserve. For an example, if any wet evidence or wet cloth, so preserved in a paper envelope, so definitely there is a growth of algae. So, it is very much necessary to make it room dried, not definitely sun dried, but room dried and then packed in a paper envelope to prevent a tampering or the evidence can be lost or degradation. So, it is very much necessary to preserve the forensic evidence properly. So, this was example of wet evidence. So, evidence tampering. So, evidence tampering refers to the deliberate action taken by an individual to modify, hide, fabricate or eliminate evidence with the purpose of obstructing an investigation conducted by a law enforcement, government or regulatory authority. It is considered a criminal violation in numerous legal jurisdictions. So, whenever there is any tampering, so for example, if forensic evidence being collected properly, preserved properly and now it is being packed properly, but if there is any tampering at any point of time, definitely that has to be sent back for a re-examine and proper resealed, but definitely it need to be mentioned by the particular expert that it was being tampered and it was resealed under the police presence. So, the destruction of document. So, according to section 204 of the IPC, anyone who conceals or destroys any document or electronic record that they are legally obligated to present as evidence in a court of law or in any legally conducted proceedings before a public official with the intention of preventing it from being used as evidence or after being lawfully summoned to produce it for that purpose shall be subject to imprisonment for maximum of 2 years or a fine or even sometime both. So, the section 204 is related with the destruction of particular document which can be as even electronic record. So, fabricating false evidence which all comes under the section 191, 192, 193. It also says as a perjury. So, section 192 of the IPC pertains towards fabricating false evidence. So, the term refers to the act of intentionally creating a situation, making a false entry in a book or record including electronic records or producing a document or electronic record that contains a false statement. So, this is the about the false statement that starts with the definition of perjury within section 191 and then self intentionally fabricating false evidence comes under section 192 of IPC and then the punishment comes under section 193 of IPC. So, the purpose of this fabrication is for it to be presented as evidence in a legal or administrative proceeding such as judicial proceeding, a proceeding before a public servant or an arbitration. The intention behind presenting this fabricated evidence is to mislead the individuals involved in the proceedings, causing them to form an incorrect opinion about a crucial aspect that could impact the outcome of the proceeding, and even there can be a difficult to give a justice to a particular victim and the accused can get an acquittal. So, it is very much necessary that to find out the false evidence part or the witnesses getting hostile or if there is any perjury. So, there should not be any tampering in evidences or there should be no any fabrication in forensic evidences. So, the punishment for fabrication as we discussed, which all these sections are involved and particular punishment comes under section 193 of IPC. Anyone who deliberately provides false testimony or creates false evidence with the intention of using it in a legal proceeding will be subject to imprisonment for up to 7 years as well as fine. Similarly, anyone who intentionally provides or fabricates false evidence in any other situation will face imprisonment for up to 3 years along with a fine. So, it is very much necessary to take care about the forensic evidence. There should not be any tampering, there should not be any fabrication, there should not be any false evidence to be admissible in the court of law, and if it is being founded intentionally, deliberately, then particular punishment being there under section 193 of IPC. So, giving or fabricating false evidence with intent to procure conviction of capital offence. Anyone who provides or fabricates false evidence with the intention of causing or with knowledge that it is likely to cause the conviction of a person for a capital offence under the current law in India shall be sentenced to life imprisonment or the rigorous imprisonment for up to 10 years and may also be fined. So, it is need to take care about the evidences involved in a particular incident and in the administration of justice. So, using evidence known to be false, anyone who knowingly and dishonestly utilizes or seeks to utilize false or fabricated evidence as genuine evidence shall be subject to the same punishment as if they had provided or created false evidence. So, you have to take care in using the false evidences. So, you should not use or fabricate the evidences. The evidences should be properly collected, preserved and dispatched, maintaining the chain of custody. So, how to dispatch the forensic evidence and maintain the chain of custody is in India the forensic expert who perform the study. So, typically presents the forensic evidence in court. The individual with specialized knowledge like a forensic person like doctors with a forensic pathologist is designated as witness, and their responsibility is to elucidate the scientific methodologies employed, the protocol adhered to during the forensic examination and the inferences derived from the analysis. So, the proper dispatch of forensic evidence is also necessary to maintain the chain of custody, definitely under the requisition of police at the level of forensic pathologist at the medical college. Police will give the requisition to collect the evidences and to be particularly note down, take a receiving and then hand over to the police to be documented, to whom you have handed over with the name, designation, signature and what all being received, being handed over to the forensic science laboratory, there also the register being maintained, and then forensic science laboratory receive and do the analysis and dispatch the reports through police back to the forensic pathology expert or other experts. So, the proper dispatch to be mandatory and maintaining the chain of custody. So, the specialist offers professional testimony to aid the court in comprehending the technical and scientific elements of the evidence. The expert's testimony is too open to scrutiny by the party who summoned the expert, known as examination in chief by the public prosecutor, and can also be questioned by the opposing party, known as a cross examination, by asking the leading question. Throughout this procedure, the expert may face inquiries regarding their credentials, the forensic analysis approach employed and the dependability of the outcomes. So, definitely the particular experts reports can be used as documentary evidence, but still the chances are there that in a very heinous crimes or specific cases they can be called for testimony. So, need to all the experts, whether that is a forensic pathology expert, forensic science expert or any technology expert, ballistic expert, fingerprint expert, DNA analysis expert. So, they can face the cross examination in the court and help to give the administration of justice by proving their report as accurate. So, the presentation of medical reports, the medical practitioner or the treating physician or forensic pathologist who perform the necessary examination or assessments usually presents the medical reports to the court during legal procedures. The procedure may differ based on the specific circumstances of the case, such as whether it pertains to a criminal law, civil law or any other legal issues. Legal proceedings involving individuals accused of committing crimes are in the specific criminal cases. The investigation stage: in the course of criminal investigation, if medical examinations are carried out, the investigating officer has the option to incorporate the medical report into the comprehensive investigation report that is presented to the court. The submission of this report is permissible under section 173 of the Code of Criminal Procedure 1973 in India. So, in particular criminal cases, how it has been proceed in an investigation stage, which comes under section 173 of CRPC. So, the trial stage as stated under section 207 of the CRPC, in the event that the matter proceeds to trial, the prosecution or the defense has the option to introduce medical reports as substantiating evidence. Typically, this is accomplished by summoning medical specialists who performed the examinations to testify as witnesses. The medical experts will provide their testimony and, if required, undergo cross examination by the opposing party. So, coming to the it was about the criminal case, the investigation stage and the trial stage. So, coming to the civil case, so what all the pleading stages. So, in submission by the parties, in case of civil cases or in a civil lawsuit, the parties are allowed to provide medical report as part of their pleadings. The responsibility for this action may lie with either the plaintiff or the defendant, contingent upon the circumstances of the case. So, the next is the trial stage of a civil lawsuit. So, document submission. Parties are permitted to present medical records as evidentiary documents during the trial. So, Order 13 of the Civil Procedure Code 1908, production, impounding and return of documents. This order deals with the production of documents, and medical reports may be submitted as part of the documentary evidence during the trial. So, this was about the criminal cases and the civil cases with the investigation stage and the trial stage, and in civil lawsuit the pleading stage and trial stage, how the medical reports are being submitted under various sections. So, the expert witnesses, which also can be as a common witness, but as an expert witnesses in legal proceedings, medical specialists can be summoned as expert witnesses to present their opinion, to give their testimony and elucidate the details of medical reports. So, Order 18th, hearing of the suit and examination of witnesses. So, this order, that is Order 18, outlines the procedures for the hearing of the suit, including the examination of witnesses, which may include medical professionals as expert witnesses. So, coming to the conclusion of our lecture is that the law enforcement agents often neglect to properly maintain the chain of custody due to their perception of its insignificance. So, you must know that what is the importance of chain custody, even from the collection which is found at the scene of crime. Should the law enforcement agency, especially the police who go with the scene of crime, you should maintain the scene of crime properly while telling the layman or the public person of the nearby area that secure the scene of crime, so that the collection of evidence by the experts, and if experts not able, you should call immediately that such scene of crime has happened. So, maintain the chain of custody. Collection is very much important at any point of time, scene of crime, at coming to the hospital level, while examining, while treating, and even in case of the deceased while doing the post-mortem examination. So, collection of evidence, and then how to preserve it. You all law enforcement agencies should know or should explain or should provide the infrastructure to maintain or to preserve the evidences. For example, of any raw material or any bottles or anything need to be done for the preservation, need to be asked by the forensic science expert and conveyed to the forensic pathologist, or forensic pathology also have a interconnection with all the law enforcement agencies who are involved in the case. So, need to maintain the chain of custody by collection, preservation, and then last with the dispatch. There should not be any tampering of forensic evidence, need to maintain the chain of custody. So, you should have a knowledge what is the importance of maintaining the chain of custody, giving the proper evidences to the technologists to give that analysis to be done properly, accurately, and help in the administration of justice in a court of law. So, however, they are unaware that the admissibility of any evidence in a court of law hinges on the quality of the chain of custody that they uphold. So, hence it is crucial to raise the knowledge of the protocol for maintaining an accurate chain of custody among the individuals involving in handling such cases to expedite justice. So, it is very much necessary to have an awareness about the how to maintain the chain of custody, how to do the collection, preservation, dispatch at each point of time from the incident happened to till the disposing of the case, till the accused get being to be guilty, victim get a justice. So, till from the starting to the end, it is very much necessary to maintain the accurate of chain custody, that knowledge being given to the law enforcement agencies or who all are the experts involved in that particular case. So, the viewers can go through these various references which we have taken in this lecture. You can have a further reading. So, first is from the Supreme Court, which has like death sentence overturned DNA sample while maintaining a chain of custody from the section 53 of CRPC, and another we have about the ballistic report, how it is being proved that to be as an documentary evidence admissible in the court of law. So, these are the references we have taken in our lecture. You all can go through these references for further readings. Thank you very much.